the so-called bail jurisprudence, because we all know that and we all talk about it, that bail is a matter of right and jail is an exception. But that is not happening. That is only happening in seminars and speeches. But in real term, it is not happening. The bail hearings are going on for 3 months, 4 months. It's a matter of bail or anticipatory bail. So why this? What is your take on this?
So there are two things. One is normal bails with normal bails in the case of normal crimes. Even there, like you said, bail hearings can get prolonged, can take months, sometimes 2 months, 3 months, 4 months to get heard. And then the general tendency has been, the Supreme Court has spoken about this, that the tendency has been for trial courts to deny bail as a matter of course. And more often than not for high courts also to deny bails. And so the Supreme Court ultimately is called upon to grant bail as the first court granting bail. And the Supreme Court itself has lamented this. Many judges have said this in open court. They have even written it in judgments. But at the same time, what does happen is that sometimes mixed messages are sent down. Sometimes when courts are quick to grant bail, they get criticized. Trial courts which are quick to grant bail get criticized by a high court or criticized by the Supreme Court. So sometimes you have, Supreme Court judges saying that this particular judge has given multiple bail orders with similar reasons. Now there are only so many reasons you can give. If you're going to be a diligent judge and you're going to grant bail, you're going to be generally giving bail wherever it's possible to give bail and denying it only where it's needed to be denied. Then your reasons are going to read pretty similar. So if you're in a criminal, in a criminal assignment in a court, in a very large court like Allahabad High Court or Bombay High Court or somewhere where there's and your assignment is bails and you're getting hundreds and hundreds of bail applications, your orders, wherever you grant bail, will tend to read, because what are you looking at? You're looking at whether the person is a threat to society, whether the person is, whether there's a
flight risk,
whether the person is, what should be the terms and conditions imposed on the person. They will tend to read similarly. So if they get criticized by the Supreme Court or by the High Court for that, then judges the trial court again go on the back foot. Then they start denying as a matter of course. So we have too much of this back and forth, going on in normal bail. Special laws like the UAPA, the Unlawful Activities Prevention Act, the PMLA, the Prevention of Money Laundering Act. The police authorities do is they make a narrative. They are not now investigating. They're picking up people on suspicion, but based on a narrative. And the charge sheets are filed of 5,000, 6,000, 7,000 pages, 12,000 pages charge sheets, which are just one long narrative. There's nothing really in those which is really matters of substance to actually nail the person or to pin the person down. The narrative is made, and that narrative becomes so difficult to overcome at the bail stage that the trial courts and the high courts, almost as a matter of course, deny bail. Then it comes to the Supreme Court. Now, the Supreme Court ultimately, faced with this situation, realized that people are languishing behind bars for 5 years, 6 years, 7 years, with no possibility of a trial getting completed in the next 5 years or 10 years. Because long narratives are woven with 380 witnesses, 560 witnesses, 1,000 witnesses, and 9 lakh pages of documents, and so on and so forth. The Supreme Court, when it was faced with this situation, that long incarcerations were there with no hope of a person getting out, and people were behind bars for 5 years, 6 years, 7 years. Then in certain earlier cases, the Supreme Court had taken the view that if there is long incarceration, that itself violates Article 21. That thought that long incarceration violates Article 21, and regardless of bail conditions, Article 21 will then trump the deleterious bail conditions. That thought lastly was cemented by a 3-judge bench in the case of K.A. Najib in 2021. Right? So, but K.A. Najib was not the first judgment to say that. This thought that Article 21 will kick in when there is a very prolonged incarceration without hope of trial had already been evolved by the Supreme Court earlier. But K. Najib was a 3-judge bench which said that regardless of the seriousness of the charges, regardless of the seriousness of the offense, if a person is behind bars for 5 or 6 years and there is no hope of an early trial getting concluded, or it is apparent that the trial it's impossible to complete the trial, then that itself is a ground for grant of bail without looking at anything further. This was laid down by a 3-judge bench in Najib. This was then followed by a number of judgments, not 1, not 2, not 3, not 4, by about 20 judgments. It has been followed. The Najib principle has been followed again and again and again under the PMLA, under the UAPA, under numerous laws, under all the laws where these triple tests are laid down. Now, there were only 2 judgments where a contrary view was taken. The first was Gurvinder Singh. And in Gurvinder Singh, they distinguished Najib for the first time in Gurvinder. That again has been followed by, in the case of Gulfisha Fatima, where the Supreme Court, in my submission, ignored the large number of judgments which said the seriousness of the charge is irrelevant. If you are not able to complete a trial expeditiously, then Article 21 gets violated and the seriousness of the charge or the wording of the law is completely irrelevant. The 3-judge bench was then followed by 2-judge benches. At least 2 of those 2-judge benches, they said the prosecution should not even be allowed to argue against bail if they are not able to ensure an expeditious trial. So Justice Pardiwala has categorically said that it will not lie in the mouth of the prosecution to argue. We will not allow the prosecution to argue against bail if they cannot ensure a speedy trial. Because speedy trial is the essence of Article 21. Now, in Gulfisha Fatima, the court again harked back to the Gurvinder Singh and on the same basis held, separated out of 7 odd persons who were facing similar identical charges. 2, they said, have played, according to the court, a higher, a greater role, and on that basis they said because they have played a greater role, they can't be let out at this stage, and they should stay for 1 more year. Now, what is the logic of 1 more year is not explained. What is the basis on where the Supreme Court says that Article 21 will be met after Article 21 will be violated after 1 year, but is not being violated today, even though charges are not framed, even though the possibility of framing charges and completing the trial is not there for the next 10 years, probably. So it is these judgments were a departure. So lastly, what happened was that another bench of 2 learned judges in the case of
Justice Bhuyan.
Justice Her Ladyship Justice Nagaratna and His Lordship Justice Bhuyan, they ruled in one matter. They analyzed these judgments and they said that these judgments are outliers. Nobody has ever said that the law changes. All that they have said is that Article 21 guarantees a speedy trial. And if the state is not in a position to provide a speedy trial, then the state cannot oppose bail.
Absolutely.
Now, that is absolutely logical. That is absolutely unassailable. That is absolutely, something which I think is unexceptionable. You can't take exception to this logic that either the state ensures a speedy trial or the person must be granted bail. That's all. That's all there is to it. There's nothing. There's no. It's not rocket science. It's not something which requires Einstein to come down from the heavens and explain this law to us. You know, we all must understand what is Article 21. It's one of the most cherished fundamental rights. It's not given to us by the Constitution. It's a basic right. It's an inherent human right. It was there from 5,000 years. It was there from 5 million years ago. Yes. Article 21 only guarantees it.
Just imagine the plight of those law school teachers. They will have to teach this. Look.
So I just feel strongly about it. I feel that we must we must apply our knowledge and apply our practical sense. Now, let me say this loud and clear, that I don't believe that any judge of the Supreme Court of India does not know, hand on heart, does not know what is the reality of these incarcerations in Bhima Koregaon, in the Delhi riots cases. I do not believe that any judge believes in their heart that there is even an iota of truth in the charges.
True.
You can put a gloss on things. You can say that, very serious allegations are made. They are allegations. They are only allegations, and every judge knows that those allegations are hollow. They will crash to the ground. They will crash and burn. Justice Sanjeev Khanna, when he was in court number 2, he said it in open court. He said, Mr. Solicitor General, Mr. Raju was arguing a matter. He said, 2 questions in cross-examination and your entire liquor scandal case will go. Right? What happened? The trial court has given a 589-page judgment saying that there is not even an iota of a case for framing of charges. Justice Sanjeev Khanna said this 2 years ago.
True.
2 questions in cross-examination, Mr. Solicitor General, your case will go. And they can't frame charges. Big liquor scandal. People were Chief Minister, Deputy Chief Minister, Home Minister of Delhi government, Ms. K. Kavita from Telangana, 23 accused, all top politicians, businessmen, etc., all discharged.
True.
So, when we talk about bail, we must know this. We know these are all hollow cases. These are all narrative-based cases. There's nothing in them. They will all crash when they are tested.